নমস্কার, বেকারের মুখপাত্র থেকে অরূপ দত্ত বলছি। নিশ্চয়ই আপনারা সকলে ভালো আছেন। মাদ্রাসা গ্রুপ ডি নিয়ে আজকে এক বিস্তারিত আলোচনা আপনাদের সামনে করতে চলেছি। আপনারা বারবার মেসেজ করেন, বারবার ফোন করেন যে দাদা মাদ্রাসা গ্রুপ ডির খবর দিচ্ছ না কেন? মাদ্রাসা গ্রুপ ডির খবর কি? মাদ্রাসা গ্রুপ ডির হেয়ারিং না হলে বিস্তারিতভাবে আপডেট আপনাদেরকে দেব কেমনভাবে? 17 তারিখ এবং 18 তারিখ দুদিন ধরে বড় শুনানি হয়েছে এবং বড় আপডেট সামনে এসেছে। আর হয়তো আগামীকাল ৭৩,০০০-এর পক্ষ থেকে ৭৩,০০০-এর আইনজীবীরা কিছু বক্তব্য রাখবেন। কমিশনের আইনজীবীদের কিছু সাবমিশন বাকি রয়েছে, সেটা হলেই ফাইনাল জাজমেন্ট চলে আসবে হয়তো বা কিছু দিনের মধ্যেই। অর্থাৎ মাদ্রাসা গ্রুপ ডিকে নিয়ে যে সমস্যা এতদিন ধরে চলছিল তার এমন একটা পর্যায়ে এসে দাঁড়িয়েছে যে সেই পর্যায় থেকে খুব দ্রুতই সমাধান হয়তো হাইকোর্টের সিঙ্গেল বেঞ্চ দিয়ে দেবে। হ্যাঁ বন্ধু, এমনই খবর উঠে আসছে। বেকারের মুখপাত্র ইউটিউব চ্যানেল প্রথম থেকেই নিরপেক্ষভাবে সত্যের পথে ছিল, আজও আছে। মাদ্রাসা গ্রুপ ডির ক্ষেত্রে ৭৩,০০০ পরীক্ষাটা যে বেআইনি ছিল সেটা নিয়ে কিন্তু বেকারের মুখপাত্র চিৎকার করে বলতে শুরু করেছিল যে ৭৩,০০০ পরীক্ষা ইল্লিগেল, ৭৩,০০০ পরীক্ষাটা ইল্লিগেল হতে পারে না। কারণ ডিভিশন বেঞ্চে এবং তার আগের সিঙ্গেল বেঞ্চ বারবার রেজাল্ট প্রকাশের কথা বলেছে। যারা লিখিত পরীক্ষা দিয়েছে তাদেরই একমাত্র রেজাল্ট প্রকাশের কথা বলেছে। নতুন করে ৭৩,০০০-এর যে গল্প মাদ্রাসা সার্ভিস কমিশন এনেছে সেটাকে কখনোই সিঙ্গেল বেঞ্চ এবং ডিভিশন বেঞ্চ মান্যতা দেয়নি এবং ২ লক্ষ টাকা ফাইন করেছিল। তারপরেও দেখা গেছে ৭৩,০০০-এর পরীক্ষা নেওয়া হয়েছে। সেই পরীক্ষাটা নেওয়ার ফলে ২৪,৫৭৭-এর মধ্য থেকে বহু মানুষ যারা দীর্ঘদিন ধরে অপেক্ষা করছে তারা বঞ্চিত হয়েছে। মাদ্রাসা সার্ভিস কমিশনের পক্ষ থেকে বারবার জানানো হয়েছে যে তারা বিভিন্ন কারণ দেখেছে বিভিন্ন সময়ে। কখনো বলেছে টেকনিক্যাল ফল্টের জন্য তারা ৭৩,০০০-এর লিখিত পরীক্ষা নিতে পারেনি। কখনো তারা বলেছে একটা ৩টে সেশনে প্রাথমিক যে পরীক্ষা হয়েছিল মাল্টিপল চয়েস পরীক্ষা, সেই প্রাথমিক পরীক্ষাতে ৩টে সেশনের মধ্যে একটা সেশনের পরীক্ষাকে অ্যান্সার কিকে কেন্দ্র করে বাকি সেশনের বাকি সেশনের ওএমআর শিটের মূল্যায়ন করা হয়েছে। তার ফলে ৭৩,০০০-এর পরীক্ষা নেওয়া ছাড়া তাদের কাছে অন্য কোনো রকম ইস্যু ছিল না। কিন্তু ১৭ তারিখ এবং ১৮ তারিখ পিটিশনারদের পক্ষ থেকে যে সওয়াল জবাব উঠে এসেছে, মারাত্মক কঠিন সওয়াল জবাব। এর পরিপ্রেক্ষিতে মাদ্রাসা সার্ভিস কমিশন এখনও এমন কোনো যুক্তি দেখাতে পারেনি যে ৭৩,০০০ পরীক্ষা তাদের কাছে সত্যিই নেওয়া বাধ্যতামূলক ছিল এবং নিয়ে তারা ঠিক করেছে। এরকম কিন্তু যুক্তি তারা কোর্টের সামনে উপস্থাপন করতে পারেনি। তাদের যুক্তি কিন্তু খুব এলোমেলো লাগছে। আইনজীবীদের পক্ষ থেকে বেশ কয়েকজনের সাথে যে কথা বলে জানতে পারা গেছে ৭৩,০০০ কিন্তু পরীক্ষা যে বাতিল হতে চলেছে এটা এক প্রকার সুনিশ্চিত করে বলা যেতে পারে। ভিতরের খবর যে 24,577-এর মধ্য থেকে একটা লিস্ট প্রকাশ হতে পারে এবং সেই লিস্ট থেকেই হয়তোবা নতুন করে পরীক্ষা, নতুন করে ইন্টারভিউ হওয়ার সম্ভাবনা প্রবল রয়েছে। কিন্তু কমিশন চাইছে যে বর্তমানে দুটো পরীক্ষাকেই বাতিল করে দিতে, যাতে 73,000 পরীক্ষাও বাতিল হয়ে যায় এবং 24,577 পরীক্ষাও বাতিল হয়ে যায়। কিন্তু বিচারপতি পরিষ্কার জানিয়ে দিয়েছেন তাহলে হাইকোর্টের ডিভিশন বেঞ্চের যে অর্ডার সেটাকে ভায়োলেট করা হবে, কন্টেম মামলা হবে এবং তার পরিপ্রেক্ষিতে কমিশন আরও বিপদে পড়তে পারে। তাই হাইকোর্টের যে অর্ডার, সেই অর্ডারকে কখনো ভায়োলেট করতে পারে না সিঙ্গেল বেঞ্চ। তাই হাইকোর্ট যেটা বলেছিল 24,577-এর মধ্যে পরীক্ষা, সেই পরীক্ষায় কিন্তু কমিশনকে নিতে হবে, এদেরই ফেস লিস্ট বার করতে হবে, এদের মধ্য থেকেই নিয়োগ প্রসেস কমপ্লিট করতে হবে। এর মাঝেই একটা গল্প ছিল, সেই গল্পটা হচ্ছে এটাই, যেই 297টা সিটের মধ্যে সুপ্রিম কোর্টে একটা মামলা চলছে, তার মধ্যে 9টা সিট এখান থেকে কমে যাবে, যেহেতু তখন কমিটি থেকে নিয়োগ করা হয়েছে। এটা নিয়েও কিন্তু পিটিশনারদের আইনজীবী জোরালো সওয়াল জবাব করেছেন এবং তার পরিপ্রেক্ষিতে কিন্তু সেই সওয়াল জবাবে সন্তুষ্ট মাননীয় বিচারপতি পার্থ সারথী বাবু। কারণ ভ্যাকেন্সি না বাড়িয়ে কমিটি থেকে যে নিয়োগ করা হয়েছে, সেই নিয়োগ এর সঙ্গে এই 297টা সিটের যে কোনো সম্পর্ক নেই, সেটা কিন্তু কোর্টকে বুঝিয়ে দিতে পেরেছে মাননীয় আইনজীবীরা পিটিশনারদের। এবং পিটিশনারদের আইনজীবীদের পক্ষ থেকে ফিরদৌসবাবু পরিষ্কার জানিয়ে দিয়েছেন নোটিফিকেশনকে তারা চ্যালেঞ্জ করেছে 73,000-এর। তার সাথে দু রকম প্রশ্নপত্রে পরীক্ষা হয়েছে, অর্থাৎ নর্মালাইজেশন যেটা হয়েছে, সেই জায়গায় দুটো পরীক্ষায় কিভাবে দু রকম প্রশ্নপত্রে মূল্যায়ন হবে, এটা নিয়ে কিন্তু ফিরদৌসবাবু যেমন বলেছেন, সৌম্যবাবু কিন্তু সেরকম একইভাবে সওয়াল জবাব করেছেন। এর ফলে যে কথা দীর্ঘদিন ধরে বেকারের মুখপাত্র বলে আসছিল যে 73,000 কোনোভাবেই পরীক্ষা নেওয়া যায় না, 24,577-এর থেকেই নিতে হবে এবং 24,577-এর একদিন বড় জয় আসতে চলেছে, এইখান থেকেই নিয়োগ প্রক্রিয়া বা নিয়োগ প্রসেস সম্পন্ন হবে, সেই জিনিসটাই কিন্তু হতে চলেছে বলে সূত্র মারফত খবর। আপনারা শুধু মিলিয়ে নেবেন যে জাজমেন্ট কি আসছে। 24,577-এর মধ্য থেকেই কিন্তু ফ্রেশ রিক্রুটমেন্ট হতে বাধ্য, যদি না মাদ্রাসা সার্ভিস কমিশন ডিভিশন বেঞ্চে এটাকে চ্যালেঞ্জ করে, পরবর্তী ক্ষেত্রে সুপ্রিম কোর্টে চ্যালেঞ্জ না হয়, তাহলে কিন্তু এই সিঙ্গেল বেঞ্চের অর্ডার অনুযায়ী কিন্তু নিয়োগ হতে বাধ্য। আর যদি চ্যালেঞ্জ হয় তাহলে কিন্তু পিটিশনারদের আইনজীবী সৌম্যবাবু তো পরিষ্কারই বলেছেন কন্টেম মামলা হবে এবং সেই কন্টেম মামলার পরিপ্রেক্ষিতে কিন্তু মাদ্রাসা সার্ভিস কমিশন আরও চরম ফেঁসে যাবে। তাই বিস্তারিত শুনুন পিটিশনারদের আইনজীবীরা কোর্টে দাঁড়িয়ে কী সওয়াল জবাব করলেন। আপনারা সবাই দেখছেন কিন্তু সাবস্ক্রাইব করছেন না, তাই প্রত্যেককে বলবো অবশ্যই করে খবরটি দেখবেন এবং বেশি বেশি করে শেয়ার করবেন এবং সাবস্ক্রাইব করলে নিশ্চয়ই অন্তত একটু অনুপ্রেরণা আপনাদের কাছ থেকে পাবো। ভালো থাকবেন এবং সুন্দর থাকবেন।
Mr. Samim,
Yes.
You are SHAMIM.
SAMIM.
No, H is absent.
Absent.
Mr. Samim,
Yes.
so far your petition is concerned, The subject matter of challenge is the notice dated
Dated-
9/8/2024.
Yes, yes.
And further is your prayer for cancellation of the written examination held on 1/9/2024.
Yes, yes, yes.
Am I correct, sir?
Exactly, my lord. Now, my lord, why I asked
এই ফাইলটা দাও গো
file
26237 এইগুলো নামো আস্তে আস্তে এইটা একটু কাছাকাছি রাখো অর্ডার শিটটা এখানে রয়েছে তো টু সিক্স টু থ্রি সেভেন ফাইলটা দিন Mr. Samim, you heard the argument of Mr. Mojumdar?
Yes, I will repeat. We will not repeat any single sentence.
Please add if you
Yes.
have got anything.
Yes,
to put.
yes. And I will, my lord, never cited the division bench because of that, my lord, already it is cited.
Yes, sir.
Kindly take, my lord, page number 14 of my writ petition. Para 14. Specific averment. What my lord says that it's specifically avoided in my writ petition, original writ petition. Your petitioner, what
Para
is
14 or page 14?
page 14, para 14. In page 14, para 14, bottom.
এটা কোনটা দিলে কোন তাহলে 26237
Yes, my lord.
page 14 there is paragraph M and N.
No, no, my lord. I believe para 14. Page 14, para 14. I believe the other writ petition is given to my lords.
I'm sorry, it is I'm seeing the AVAB notice.
It's original writ petition, my lord.
I got it. Sorry.
It's okay. It's okay.
Yes, sir.
May I start, my lord?
Yes.
Your petitioner state that the action of the commission is also contrary to the recruitment rules. There is no provision to conduct a separate written examination. That's my point. There is no mechanism mentioned in the recruitment rules to meet up the problems of separate examination. The question paper were not same in case of separate examination. An easier question may given in new examination to make a pathway for their favorite examiner. In other examination where two or more separate question paper were set, in many cases, normalization mechanism were followed. But in the instant case, there is no such mechanism to put all participants in same footing. In what happened, my lord, in central government, suppose 2 days or 3 days, the examination is conducted. In the case of railway, they adopt a mechanism that's called normalization mechanism. But here, my lord, I will place the recruitment rules later on. Because in that examination, if you want to put separate sets of question paper, then you ought to adopt a mechanism, that a modern mechanism that's called normalization. Normalization, scaling, all are the mechanism to meet up this type of problem. But here the case is that, my lord, they complete divorce the recruitment rules. I will place the rules later on. Before that, my lord, I place my case, my lord, in pleadings, my lord. No such mechanism to put all participants in same footing. Recruitment rules did not mention about any such mechanism, but the commission has taken a separate written test for the 73,978 candidates. The action of the respondent commission cannot sustain in the eye of law. Therefore, said notice dated such and such and the impugn action of the respondent need to be set aside as early as possible by the Honorable Court. Para 15. Your petitioner state that the notice by the commission is bad in law, bad in the eye of law. It is contradicting the order of the Honorable Division Bench. That means 13 June 2024 Division Bench order. The petitioner state that it has been decades since the examination was held. The writ petitions filed before the Honorable Single Bench was with the prayer for publication of result, which has not been complied with. The petitioners, along with several same footing candidates, are suffering due to the delay, and holding another written test would create further complication and delay, and the petitioner will be deprived of the opportunity. The commission cannot conduct a fresh examination of same candidate. The examination process need to be declared as bad in law. Now, my lord, what was the commission stand in earlier before the division bench, my lord, through CAN 20, which is annexed with the comprehensive affidavit. Well, let kindly take the comprehensive ability.
Comprehensive ability লাগবে কোথায় গেল comprehensive ability কোথায়
Comprehensive in comprehensive ability.
নামালে ওটার মধ্যে আছে
No, no, no.
24588 এর মধ্যে আছে
একটাই স্যার পেজ নাম্বার 152
24588 এ পাঠাও কেন খুলতে বলেছি দেখেছো তো আজকেই খুলবে সব yes
Well, let kindly take page number 152. On 13 June 2024,
give me a
Yeah.
second give me a second yes
on 13 June, my lord, this application was moved before the division bench. In connection with MAT 907, CAN 20 was moved before the division bench. What was the pleadings in this CAN? That is important. 152, page number 152. We start from page number 152. I just skip the para 1 and 2. Para 3 is very relevant.
yes
I read. The appellant, that means the appellant commission, state that on 19 September 2023, during the pendency of such application, the had already taken a policy decision to conduct a fresh written examination of total of 1,164 candidates. The commission take this policy decision. My first question is that from which provision of law they got this power, empowered? How the commission is empowered to take a policy decision after finishing everything, they will conduct a further written examination. Now, a very interesting fact came out thereafter. Of conduct a fresh written examination of a total of such and such candidate, that is 74,618 eligible candidates, which were left out along with 26,444 candidates who had already appeared in the written examination of Group D held on 29th May 2011. The appellant the very next paragraph. The appellant state that upon passing of the order dated such and such, the following step has been taken to comply with the order passed by the Honorable Court.
Mr. Samim,
Yes, my lord.
so far as paragraph number 3 is concerned,
Yes.
What is the stand of the commission? The commission
Commission,
intends to take examination of all the candidates.
no. Kindly take this. May I read again?
Commission had taken a
The
policy
it will clear by the last two line. Page 156. It is cleared by the last two line. They want to conduct further examination, although this is not a very clear, but the intent is that the spirit of this paragraph is that they want to conduct fresh examination in respect of 74,000.
Sir, just a minute, sir. Had taken a policy decision to conduct fresh written of a total of no, Mr. Samim. Paragraph 3 says such and such had taken a policy decision to conduct fresh examination of a total of 1 lakh and what candidates.
Yes.
So their intention is to take fresh examination of the candidates of 1 lakh and odd. That is 74,000 and odd eligible candidates which we have left out along with.
That
So
is
they intend to take the fresh examination.
thereafter the sentence is not yet completed. That is, i.e., 74,618 eligible candidates which were left out, along with 26,445 candidates who had already appeared. That means who already appeared, which will be more clear because of they give a tabular chart.
Mr. Samim, paragraph 3 clearly indicates that the commission had taken a policy decision to conduct a fresh written examination of total 1 lakhs and odd candidates, which includes 74,618 were left and to plus 26,448
Already appeared.
already happened.
So
Sum total will come
that is the number. Because of that, kindly take page number 4 of this comprehensive.
Just a minute.
Before that, kindly, if my lords wants a list of date, that will be give a clear picture to before this court, my lord, page number 4 of this comprehensive affidavit.
Just a minute, sir. 74, 618, 26, 417, 6, 10, sum total comes to 1,063, 64.
Kindly-
That is they intend to take a
Kindly
fresh examination.
yes, no. Kindly take, my lord, page number 4 of this comprehensive affidavit. Page number 4.
Just a minute.
It give a list of date that will give the clear picture of this about this matter. How this matter is cropped up. Para 5.
Page number
4 of this comprehensive. Because this is it will help the court to ascertainment the fact. List of dates. The first entry, that is 27th March 2010, that is the publication of the advertisement date. Second entry, the commission conduct preliminary examination on 28th November 2010. The third entry, about 26,000, which my lord asked me about this 26,000. On 29th May 2011, already 26,445 candidates, they appeared in the written examination. There are second stage. So they appeared. What they did, they says, I will read the whole application. Because of that, what is the necessity of the reading, that will give the clear picture. I just put this list of date. Why? Because of that, it will give the clear picture. On 12 March 2014, the High Court order. Thereafter 9th December 2015. Thereafter 14/3. I just skip over. They even quoted in their tabular chart, and kindly take entry number 13. They even took cognizance of the division bench order. They already complied the division bench order by giving the cost portion. They can't take the contrary stand now. They already complied the order because they already gave the 2 lakhs cost. Now, after that, because this order came out after this application, moving this application, I will tally this application along with this comprehensive affidavit. Why? Because they took, which is already the decision is taken by the division bench. Now they wants to re-agitate the same issue. Even the paragraph is totally the same. I will compare this to affidavit, this application along with this comprehensive affidavit. I will tally it. That's why I placed this application. Now, my lord, kindly take para 5.
Para 5 of what?
Of this scan application, page number 158. Page number 158. 8. They're comprehensive. The appellant further state that they have issued letter dated such and such to the district magistrate seeking for the availability of examination center to enable the appellant to conduct examination shortly. That means fresh examination of left out candidate. Such information regarding the availability of examination center is of vital importance for the issuance of admit card. Copy of the letter such and such. I just skip this portion, para 5, para 6. Now kindly take paragraph 8 and 9. 7, 8 and 9.
Page number
160. Got it, my lord?
Yes, sir.
Para 7, it is stated that as a result of aforementioned pre-scheduled business of appellant, that is conducting recruitment process of assistant teacher, the appellant have been under immense pressure and were unable to complete the entire recruitment process for the post of Group D in terms of order dated 12 September 2023. That paragraph 8, that the order dated 12 September 2023 is due expire on 11 March 2024. However, the appellant, despite the best effort, were unable to complete the entire process of recruitment of Group D candidate. Were unable to complete the entire process of recruitment of Group D candidate within such time frame as directed by this honorable court. Paragraph 9, very interesting. The appellant further state that they have received letter from the district election officer stroke district magistrate for the requisition of numerous staff of the West Bengal Madrasa Service Commission for the upcoming general election to the Lok Sabha 2024. Copy of the letter received from the district magistrate election officer stroke district magistrate is annexed here too and marked with letters such and such. Now, my lord, kindly turn page number 19. Now their stand. What is their stand? Same stand. Para 19. M. Paragraph M. Paragraph 19. That after 12 September 2023, the commission again started process of re-evaluation of the OMR sheet. My second question, my first question was that from where they got this power to conduct a further written examination, because there is no such normalization procedure, because separate set of question paper, that is my first points of agitation. Second point of agitation, this re-evaluation. From where they got this power of re-evaluation of OMR sheet? Because if they want to re-evaluate the OMR sheet, there must be some statutory backup, because division bench is very clear. And
Give me a second. Yes, Mr. Sain.
Yes, Margaret. So there is no such provision of re-evaluation of OMR sheet. My second point. Re-evaluation of OMR sheet of all the session and preliminary examination for the
Second or third point.
The
Your
third
first
point
point was violation of recruitment rules.
Yes.
Your second point
That-
was no mechanism has been followed for normalization of the recruitment process.
There is no rule regarding second time holding of the written examination. So
And
there
third
is
is no power to re-evaluate the
the
OMR.
OMR. Yes,
As
I'm
per
grateful.
the
Yes,
recruitment rules.
yes, I'm
Those
grateful.
are the basically 3 points.
3 points. I will come up another points also.
Very good.
Normal re-evaluation of OMR sheet of all the sessions of the preliminary examination for the post of Group D held on such and such date with proper answer key of those respective session. And thereafter, it was detected that 73,978 candidates who had appeared in the preliminary screening examination for the post of Group D on such and such date were eligible for written examination held on such 29th May 2011, but had not allowed to sit in the said examination held on 29th May 2011 due to the technical error of the commission as stated herein above. The commission could not complete the whole process due to Lok Sabha election 2024. After completion of the Lok Sabha election 2020, the same point, because of the earlier occasion in Can 20, they took the same point. Here also, they took the same point, and the fate of the Can 20 is already decided by the division bench. How can they re-agitate the same point which is already decided? That's why I compare this paragraph with the earlier application.
judge's copy রাখো। In the written test scheduled to be held on September 1, 2024 for selection of successful candidates in first SLST non-teaching group D. Learned advocate appearing for the writ petitioners at the very outset draws attention of this court to an order of 23rd July 2018 passed by a coordinate bench in Shoumen Malakar. Attention of this court is also drawn to the order dated February 4, 2020 passed by a division bench of this court in mat number so and so. There's the Madrasa Commission's appellate order which Mr. Bose has placed before your lordship. It is submitted that the order of the learned single bench dated July 23rd, 2018 was assailed before the division bench in mat number 907 of 2018 whereby and wherein the division bench by its order dated February 4, 2020 while disposing of the said writ appeal and while rejecting the said interlocutory application did not grant permission to the West Bengal Madrasa Commission to take further written test in respect of the said examination. That's my submission. It is also submitted that the impugned notice dated 5th August 2024 is contrary to the spirit of the order of the division bench and that the same is required to be stayed. While opposing such contention, learned advocate for the West Bengal Madrasa Service Commission submits before this court that the present writ petitioners being unsuccessful candidates have no locus standi to challenge the said notification of August 5, 2024. That's the first objection. It is further submitted that in the previous round of litigations, the present writ petitioners were not the parties and therefore they cannot take advantage of the order passed by the division bench. Now, this is something which your lordship will kindly consider, keeping in mind that it's a question of finalization of a process. It is also submitted, that's the learned counsel for the commission, that pursuant to the said notification, written examination has already been conducted and the merit list has already been published in respect of the successful candidates. On perusal of the entire materials placed before this court, and after hearing learned counsel for the contending parties, it is not in dispute that the subject matter of the instant litigation and the subject of the earlier round of litigations is identical, which is with regard to the recruitment examination of the first SLST Group D. In course of hearing, learned advocate for the commission made an attempt to distinguish the facts of the instant case with the facts involved in the earlier round of litigations. Since in the earlier round of litigations, the writ petitioner is different from the present writ petitioners. From the order of July 23rd, 2018 passed by the coordinate bench in WP 2018 and the order dated February 4, 2020 passed by the division bench in Mat of 2018, it appears to this court, at least prima facie, that in course of the earlier round of litigations on behalf of the Madrasa Commission, an application was filed for extension of time to complete the recruitment process, and in disposing of the said application along with the said appeal, the division bench took the following view. We would have proceeded to reject the said application, but considering the plight of the candidates who have participated in the written examination and because of the careless conduct of the authorities, their fate is still in large or in other words uncertain. We feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. We are unable to comprehend the stand of the appellant that further written test is required to be conducted, when the same was not accepted by the single bench as well as the division bench, and the direction was plain and simple that after conducting the written examination, the answer scripts are to be evaluated and the panel is required to be prepared indicating the successful candidates. On perusal of the aforementioned order, it thus appears to this court while disposing of the said appeal that the division bench did not permit the commission to conduct further written test in respect of the aforementioned recruitment examination. Admittedly, the present petitioners were not the writ petitioners in the earlier round of litigations. By taking advantage of the same, in considered view of this court, the commission cannot be permitted to take any further written examination in respect of the aforementioned examination, which was sought to be done by issuing the letter dated August 5, 2024, and which is under challenge before this court. It is submitted at the bar that in the meantime, the written test has already been conducted and the list has been published with regard to the successful candidates in the written test held on September 1, 2024. Such being the position, this court considers that the petitioners are successful in making out the prima facie case for obtaining an order of stay. This court further considers that in the event the stay order as prayed for is not passed, the writ petitioners may suffer irreparable loss and injury, especially when the balance of convenience is in favor of the writ petitioners. In view of such, the commissioner is hereby directed not to proceed any further pursuant to the notice of August 5, 2024 till so and so date or until further order whichever is earlier, the writ petition is required to be heard on merits, then not directions for exchange of affidavits. So two things were addressed at the interim stage. One, whether at our instance the writ petition could be maintained, and number two, whether the situation warranted taking of a second examination, and apropos the observation or not the intent of the order passed by the Honorable Division Bench. But according to us, not the Division Bench order has sealed the fate of the Commission in taking a second examination. Not in not same process, not came to be considered at the interim stage by our coordinate bench.
The final hearing of a matter, the interim order is not to be seen, not to be placed.
Your lordships will consider not whether
No, all interim orders will merge with the final order.
Because the interim order, they may march, may not march. But the
Very
interim order is not to be
I
seen.
shall consider. Yes.
not not even not the law is well settled that even not a judgment which is set aside facts recorded in the order are to be looked into.
I believe this order, upon this order, an application is also filed.
Not I'll show the nature of the application.
Yes, yes.
Yeah.
For modification of the order, something like that. Upon,
In another writ petition, there is an application for
yes, yes,
modification
I
of
know,
order,
I know.
which restricts the commission stand to 9 seats only. 25th November 2024.